So we have an important update in a critical rifle and magazine ban challenge. The Trump administration just stepped up once again, and now they're asking to join and argue that a state's ban on rifles and magazines is unconstitutional, and they want to step in during the oral arguments. So let's break down what is now happening in this critical challenge. Now, before we break into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm has amazing supplements. I highly recommend their pre-workout, and I also highly recommend their protein powder. I really enjoy the Formula One mint chip flavor. That's one of my favorites. And one of the really cool things about 1st Phorm is they're pro-America, pro-freedom. They support the Second Amendment and what we talk about here on the channel, and their culture is unmatched. It bleeds into everything that they do, and that's why they are such a solid company. So if you want to get great supplements and support a great company, check them out using the links down below. If you order something $100 or more, you will get free shipping and also a 30-day money-back guarantee on your order. Now, as I mentioned in the intro, we have some great news in a critical case challenging the state of Illinois' ban on so-called assault weapons and their magazine bans as well. The Trump administration recently stepped up to file an amicus brief in this case, arguing that the state's rifle ban and the magazine ban, along with a lot of their other restrictions, do in fact violate the Second Amendment and that they need to be struck down. The Trump administration recently filed an amicus brief, arguing that Judge McGlynn's decision actually should stand and that the 7th Circuit should find that the rifle and magazine bans are unconstitutional in light of what the Supreme Court has said in cases like Bruin. And now the Trump DOJ has also stepped up and asked for the 7th Circuit to allow them to participate in the oral arguments that are taking place in September. This is great news, and it's great for this case because not only do you have the Trump DOJ filing an amicus brief, but now they're asking to actively participate in the oral arguments on the Pro 2A side. So this is great news and has big implications for this case and these challenges going forward. Now, you might remember that originally in multiple cases, a district court issued preliminary injunctions that were intended to halt the enforcement of PICA. However, the state of Illinois appealed those preliminary injunctions to the 7th Circuit, who then upheld those bans, which then led for multiple cases to seek immediate emergency Supreme Court intervention. But the Supreme Court denied review to all of those Illinois cases. However, in that denial there, you did have Justice Thomas state that if the 7th Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the case reaches a final judgment. He stated that the court must not permit the 7th Circuit to relegate the Second Amendment to a second-class right. So although the Supreme Court denied review to these cases, Justice Thomas did send a warning signal to the 7th Circuit that they are keeping their eyes on these cases and they will review them. That is also echoed by the recent denial order in the Snope case that recently made its way to the Supreme Court. There you also had a denial statement made by Justice Kavanaugh, where he said that the Supreme Court knows they will need to address these rifle bans and magazine bans in a term or two, and that they're going to be watching cases like this one out of the 7th Circuit. Now, while all that was happening, the lower court judge here in this case, Judge McGlynn, decided to move on the case and issue a decision on the merits. And on review of the merits, Judge McGlynn once again found that PICA is unconstitutional and he struck it down. Now, Illinois then appealed once again to the 7th Circuit, arguing that Judge McGlynn got the analysis wrong. He got the analysis wrong under Bruin and should have followed what the 7th Circuit said already in some of their cases like Beavis. However, now things just got really interesting in this challenge because the Trump administration stepped up in support of this case. Now, in that recent brief, the government there argued that 3 years ago, the Supreme Court issued a landmark decision meant to break a habit developed by some states of treating the Second Amendment as a second-class right, subject to an entirely different body of rules than others and other constitutional rights. Regrettably, not every state got that message. Just a few months after Bruin, Illinois outlawed some of the most commonly used rifles and magazines in America via a so-called assault weapon ban. In doing so, Illinois violated the Supreme Court's clear directive that states cannot prohibit arms that are in common use by law-abiding citizens for lawful purposes. They state that now, after final judgment, there are 3 very good reasons why this court should reverse the course and affirm the district court's injunction. First, as explained below, key aspects of Beavis's analysis are wrong, even judged against the Supreme Court's Second Amendment case law that existed at the time. Second, multiple Supreme Court justices, including Bruin's author, have since made it clear that they disagree with Bevis and other recent lower court opinions, and that the court is likely to grant cert in a term or two to address these very errors and those opinions. Third, after this court's decision in Bevis, the district court held a multi-day bench trial, heard significant evidence regarding the issue in this case, and made factual findings that show that the act violates the Second Amendment as applied to the semi-automatic firearms and the attachments that are in common use by law-abiding citizens for lawful purposes. For all these reasons, this court should reverse course and affirm what the district court said in the injunction. They even point to the Supreme Court's recent ruling in the Smith & Wesson case, which dealt with the PLCAA, and there you had justices like Kagan herself and Thomas acknowledge that the AR-15 is in common use for lawful purposes, and it's one of the most common civilian rifles that's picked and used today. Now, there's a lot more to the arguments, but that gives you a good idea of, the strong two-way stance that's being taken by the Trump administration and how they are supporting this challenge. And now the Trump DOJ has taken an additional step, and they've gone even further by asking for permission to actually participate in the oral arguments in this case. They recently filed a motion to the Seventh Circuit. The motion states that pursuant to the Federal Rules of Appellate Procedure 27 and 29A8, the United States respectfully seeks permission to participate in oral argument of this appeal on 5 minutes of time ceded by plaintiffs' appellees. If the court grants this motion, the Assistant Attorney General for the Civil Rights Division of the Department of Justice, Harmeet Dillon, will present oral argument on behalf of the United States. This court's calendar currently indicates that the court has allotted 45 minutes of argument into time to the defendants, appellants, and 45 minutes to the plaintiffs' appellees. Counsel for plaintiffs' appellees consent to this motion and have agreed to cede 5 minutes of their oral argument time to the United States in this motion if it is granted. As a result, the United States' participation in oral argument will not affect the overall time allotted for this case. Counsel for defendants' appellants do not oppose this motion. So this is great news. All the parties, including even the state of Illinois, agreed to allow the Trump DOJ to participate in the arguments, and it's likely that the Seventh Circuit will allow them to participate in the oral arguments. Even if the decision does not actually go our way in the Seventh Circuit, you now have the Trump DOJ taking an active role in this case. They're arguing during the oral arguments, which bodes well for the challenge as it gets elevated eventually potentially to the Supreme Court as this develops. So all of this is good news, and it's going to come to a head during the oral arguments, which are now set to take place Monday, September 22nd. It's going to be interesting to see how the state of Illinois and the Seventh Circuit judges actually handle the Trump administration, their amicus briefs, and now their active participation in the oral arguments and what they're going to state during those oral arguments. Regardless, I will note that the Seventh Circuit's track record has not been good when it comes to the Second Amendment. They are now going to have to consider what they want to do going forward, because the Supreme Court has sent them warnings multiple times. And if they decide to just outright defy those and, just dismiss that and not rule in alignment with Bruin, this is one of those cases that will get elevated to the Supreme Court. However, I will say also along with that, Kavanaugh said that the time is going to come soon, maybe in the next term or two, where they're going to have to address these rifle and magazine bans. And this is one of those cases that they identified that they will be watching. So if the Seventh Circuit continues to defy the Supreme Court and they don't take the Trump DOJ's involvement serious, this could be one of those challenges that ends up in the Supreme Court and makes its way to the Supreme Court, and the Supreme Court would likely be interested in this, especially if you have the federal government, the Trump DOJ, saying, yes, Supreme Court, you should grant review to this case, especially if they're taking an active role in the arguments. So that's what's currently going on in the Illinois PICA case. Now the Trump DOJ is likely going to be involved during those oral arguments. We're going to see them argue on the pro-2A side during those arguments. So this is going to be very interesting. As we get more information, as this develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armedscholar.com. Over there, we have a lot for you guys that you can check out. Also, we have the free legal guide over there that you can find, but I will also link that down below in the details section in the pinned comment if you want to get that. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.